Alright, my curious minds and fellow skeptics, welcome back to the channel. Today we're going to break down one of the most astonishing legal and political chess moves I've seen in recent memory. Something so intricate and brazen that it almost defies belief. You might have caught some headlines. Something about Donald Trump, his family, and the IRS, with many reports focusing on the seemingly unbelievable outcome. The Trump family essentially secured an amnesty, a complete pass on all their historical federal tax issues. The IRS, an agency infamous for taking down even the most hardened criminals and untouchable tycoons. An agency that routinely tops the most feared list among federal entities, was, in essence, utterly defeated by the Trumps. To put it bluntly, according to an agreement reached, no matter what potential federal tax problems the Trump family might have had historically, the IRS is now officially barred from ever investigating them. The idea that the IRS, an institution that routinely ducks no smoke, was forced to issue a get-out-of-jail-free card to the Trump family is so fundamentally ludicrous that it almost distracts from the true brilliance and danger of what actually transpired. And that, my friends, is the real story here. It's how Trump's team designed and executed a truly genius plan, suing themselves, then settling with themselves, thereby creating a bespoke mechanism for tax immunity, and, simultaneously, orchestrating a massive transfer of over $1 billion from the US Treasury to construct a loyal MAGA army. This is next-level manipulation, a strategic masterpiece, and it reveals some dark truths about how power can be wielded within our system. This whole saga, this masterclass in legal jiu-jitsu, really kicks off back in 2016. From the very beginning of his first presidential campaign, Donald Trump consistently refused to voluntarily release his tax returns. Now, technically, this isn't illegal, but it absolutely shattered decades of established presidential precedent. Ever since Nixon, every U.S. president has publicly disclosed their personal tax returns, a performative act of financial transparency. But Trump, he always cited the convenient excuse that his tax returns were under routine audit by the IRS, which is why he couldn't release them. Of course, the rumors swirled endlessly about Trump potentially avoiding or evading taxes. And the Democrats, naturally, seized on this, constantly asking, if you have nothing to hide, why won't you just release them? Then, a pivotal character enters the scene, a man named Charles Littlejohn. And seriously, with a name like Littlejohn, you just know this guy's got some serious grit. Littlejohn had previously worked for Booz Allen Hamilton, a consulting giant that consistently secures massive outsourcing contracts from government agencies like the Department of Defense. And you guessed it, the IRS as an outsourced technical contractor. Littlejohn was stationed at the IRS for 5 years, starting in 2008, during which time he gained intimate knowledge of the IRS database's underlying architecture. He then left in 2013. 4 years later, he re-established contact with his former employer, Booz Allen, and with his wealth of experience, was quickly rehired, and once again dispatched to the IRS. According to Littlejohn's own testimony years later, his return to Booz Allen in 2017 was absolutely premeditated. He claimed to be outraged by Trump's persistent refusal to release his tax returns, believing that Trump posed a grave threat to American democracy, and that the public had an undeniable right to know the truth about Trump's financial situation before the next election. So he decided to return to his former employer, specifically so he could be reassigned to the IRS, giving him the perfect opportunity to infiltrate the system, extract Trump's tax records, and bring them to light. Court records paint a fascinating picture of his methodology. Leveraging his intimate familiarity with the IRS database, Littlejohn employed incredibly broad search parameters, conducting a fuzzy search, which allowed him to successfully bypass the sophisticated account monitoring and alert systems specifically designed to protect high-ranking officials, including the president. He then used a modified iPod. Yes, an iPod, to seamlessly copy 15 years of Trump's tax returns and related data between August and October of 2019. He anonymously leaked this trove of data in batches to the New York Times. In September 2020, just 2 months before the crucial U.S. presidential election that year, the New York Times unleashed a series of explosive articles, publishing the information Littlejohn provided. The bombshell revelation: Donald Trump, the self-proclaimed billionaire real estate magnate and sitting U.S. president, had, in his first term, in 2016 and 2017, paid a paltry $750 in federal income tax each year. Furthermore, his golf courses and hotels for many years prior had claimed massive losses, thus avoiding paying a single cent in federal income tax. This news instantly ignited a firestorm of public outrage and undoubtedly played a role in Trump's defeat to Joe Biden in the 2020 election. But Littlejohn didn't stop there. He went on to acquire the tax returns of the top 7,600 wealthiest Americans, including figures like Elon Musk and Jeff Bezos, and then handed this data over to the renowned independent media outlet, ProPublica. While Little John genuinely believed he was acting as a digital Robin Hood, righting a wrong, his actions were, undeniably, serious federal crimes. Law enforcement, using advanced technical means, eventually identified and apprehended Little John. He was ultimately charged with unauthorized disclosure of tax returns and return information. After reaching a plea agreement with prosecutors, he was sentenced to 5 years in prison in January 2024. The presiding federal judge, in a scathing courtroom admonition, rebuked Little John for placing himself above the law for attempting to reshape the nation's political landscape through criminal acts. But Little John's sentencing was not the end of this intricate drama. Fast forward to January 2026. A year after Trump presumably returns to the White House as president, he, along with his 2 sons and their company, jointly filed a lawsuit in the U.S. District Court for the Southern District of Florida, suing the IRS and its parent agency, the U.S. Treasury Department. They accused the IRS of gross negligence in failing to establish effective data monitoring systems, which led to the catastrophic leak of Trump's tax information, causing devastating damage to the reputation of the Trump family and their businesses. They demanded a whopping $10 billion in compensation from the IRS and the Treasury. Concurrently, the Trump family filed an accompanying lawsuit against the Department of Justice, arguing that the 2022 FBI raid on Mar-a-Lago concerning classified documents and the previous special counsel investigation into alleged Trump-Russia collusion were all instances of political persecution and illegal harassment by the federal government. For this, they demanded an additional $230 million from the Department of Justice. Now, traditionally, the IRS is not an agency you want to cross. You pick a fight with anyone else, but you don't pick a fight with the IRS. If you doubt that, just ask Al Capone, the notorious leader of the Chicago outfit and the undisputed emperor of the Prohibition-era underworld, despite his rampant bootlegging, racketeering, bribery, and murder. Local law enforcement and prosecutors struggled for years to bring him down. It was the IRS ultimately that sent him to federal prison. In 1931, Al Capone was convicted of income tax evasion, sentenced to 11 years, fined $50,000, and ordered to pay $215,000 plus interest in back taxes. Historically, not only crime bosses but even presidents have had to bend to the will of the IRS. Nixon, during his presidency, famously attempted to weaponize the IRS, using tax audits to target his political enemies. But the IRS at that time maintained an extraordinarily high degree of professionalism and independence. Both IRS commissioners during Nixon's tenure valiantly resisted the president's pressure, subtly and overtly refusing to cooperate in using tax measures against political opponents. They even pushed Congress to strengthen protections for taxpayer information. Even more ironically, in 1973, Nixon's own tax returns triggered an automatic alert in the IRS computer system. Despite earning a substantial $200,000 presidential salary, he exploited loopholes to reduce his tax bill to mere hundreds of dollars. Although initial officials considered letting it slide, a righteous IRS employee leaked the story to the media. The entire nation erupted in outrage. Nixon was forced to publicly defend himself, famously declaring, "I am not a crook," and voluntarily requested an investigation. The IRS and Congress, operating with impartiality, swiftly confirmed the fraud and issued a super penalty of over $476,000, an amount that comprised nearly half of Nixon's entire net worth at the time, almost bankrupting him. But with Trump, things are fundamentally different. This time, the IRS lost comprehensively. Not only did the IRS make a critical error that gave Trump a legitimate pretext for attack, but more significantly, this lawsuit presented a truly unprecedented judicial anomaly. Everyone involved, both directly and indirectly, was essentially a Trump person. The lawsuit was filed in January 2026, by which time Trump would presumably be the sitting president, meaning he would be the ultimate head of the federal executive branch. This implies that in this lawsuit, the plaintiffs were Trump, his 2 sons, and Trump's company, while the ultimate boss behind all the defendants, including the IRS, the Treasury Department, and the Department of Justice, was also Donald Trump. It was, in essence, Trump suing himself, and it gets even crazier in terms of practical execution. The plaintiffs' lawyers were naturally hired by the Trump family, but even the defendants' lawyers were effectively Trump's people. When federal agencies are sued as defendants, the Department of Justice is constitutionally mandated to assign its own employees as defense attorneys, responsible for crafting defense strategies and representing the federal agencies in court. After the previous Attorney General, a staunch loyalist named Pam Bondi, was fired, the position of Attorney General was continuously filled by acting Deputy Attorney General Todd Blanche, and Blanche, conveniently, was one of Trump's most loyal private attorneys before Trump became president. This meant that if any DOJ staff attorney dared to assert judicial independence in this case, their fate would be sealed, replaced, or fired by acting Attorney General Blanche. And indeed, that is precisely what happened. In reality, the technical bureaucrats within the IRS, ever the steel backbone of the institution, had not given up the fight. They meticulously prepared a 25-page professional defense memorandum, ready to argue their case vigorously in court. Their defense strategy emphasized that a crime committed by an outsourced employee did not equate to government agency negligence, and also highlighted that the lawsuit had already passed the statute of limitations. Among other points, however, this critical memorandum was never used in court. Because the Department of Justice lawyers representing the IRS refused to adopt it, the federal judge overseeing the lawsuit, Judge Williams, had clearly identified the glaring legal paradox embedded within this case. The U.S. Constitution, Article 3, mandates that for federal courts to take on a case, it must possess genuine adversity, meaning there must be a fundamental and real conflict of interest between the plaintiff and the defendant. Conversely, if the plaintiff and defendant are essentially in cahoots, or if one party can completely control the other, this constitutes what is legally known as a collusive or sham lawsuit, which a judge can dismiss. The Trump versus IRS case perfectly fit this description. The plaintiff and defendant were both, ultimately, Trump's people. The judge was clearly unwilling to play along with this legal charade. In April, he issued an extremely stern ultimatum demanding that the plaintiff's legal team, representing the Trump family, provide a written explanation by May 20th, clarifying whether genuine adversity existed in the lawsuit. Failing to do so, he threatened to dismiss the case. Now, the problem was, this simply couldn't be explained away, because the reality was, they were all essentially family. There was no genuine adversity. So, they decided to just drop the pretense. In an unprecedented move in U.S. judicial history, Trump's legal team, 2 days before the judge's deadline, on May 18th announced that they were voluntarily withdrawing the lawsuit. They were dropping it. A plaintiff's voluntary dismissal does not require judicial approval, thus stripping the federal judge of his jurisdiction over the case. The lawsuit was gone, and with it, the judge's ultimatum became irrelevant. But here's the most critical part. Before officially withdrawing the lawsuit, the plaintiff, the Trump family, reached a historic settlement with the defendant, none other than the Department of Justice, led by Trump's confidant, Todd Blanche. The terms of this settlement were breathtaking. First, the federal government officially issued a written apology statement to Trump and his family, acknowledging its severe negligence in protecting tax privacy. Second, the Department of Justice agreed to directly allocate $1.776 billion from the Federal Judgment Fund to establish an anti-weaponization fund. This fund is intended to compensate individuals who were allegedly persecuted by the federal government through the weaponization of justice in the past, especially during the Biden administration. The total amount of this anti-weaponization fund is $1.776 billion, a symbolic figure representing the year of America's founding, 1776. Simultaneously, Trump publicly promised that he and his family would not take a single cent from this fund. The MAGA faithful, naturally, went absolutely wild. The very setting of the compensation amount was patriotic, and Trump's selflessness in their eyes was undeniable proof that they hadn't misjudged their man. But the most audacious and frankly disturbing concession was the third term. On May 19th, the Department of Justice added a one-page supplementary document which stipulated that the U.S. federal government is permanently prohibited and excluded from conducting any further audits, investigations, or criminal prosecutions regarding the existing tax issues of Donald Trump, his two sons, and the Trump Organization. In simple terms, all historical federal tax-related issues for Trump, his family, and his businesses, existing prior to May 18, 2026, the day they reached this settlement with the Department of Justice, are now officially off-limits. Any ongoing investigations are to cease immediately, and no new investigations can be initiated. Like every major event in contemporary America, public reaction to this compromise between the Department of Justice and the Trump family has been extremely polarized. Trump's supporters, the MAGA faithful, largely celebrated, applauding the move. Their argument is that objectively, in the past decade, the U.S. has increasingly and openly weaponized its justice system to target political opponents, or, more specifically, to actively try and prevent Trump from winning re-election. This phenomenon, they argue, was initiated and escalated by Democrats, particularly during Biden's presidency. They couldn't beat him on the electoral battlefield, so they resorted to other means. From this perspective, Trump's creation of the Anti-Weaponization Fund has a certain degree of legitimacy, especially given his explicit promise that he and his family would not personally benefit from it. In the eyes of MAGA, this isn't just about righting wrongs. It is an act of moral righteousness, and a display of profound wisdom. Opponents, however, have equally valid and grave concerns. First, The IRS's commitment to forever cease investigating all historical federal tax issues of the Trump family is inherently preposterous, beyond the blatant implication of guilty until proven innocent. But now we're just letting you off. The crucial issue is that Trump's team has creatively established a new type of judicial immunity through a legal settlement agreement, one that exists completely outside of constitutional provisions. This, yet again, sets a dangerous precedent. Furthermore, the specific operational details of this righteous anti-weaponization fund are, to put it mildly, problematic. The day after the settlement terms were announced, Democratic congressman, seizing the opportunity during Acting Attorney General Todd Blanche's appearance at a hearing, furiously grilled him about the fund's regulations. Blanche personally revealed the following chilling details. The anti-weaponization fund's scope of applicants is completely unrestricted. It is not limited to compensating victims during the Biden administration. Even those involved in the January 6, 2021, Capitol riot can apply.